Hello and welcome to Macros with Mythili, the ET Now show that takes a hard look at all the major macroeconomic issues and developments in India and overseas. This week we're going to take a hard look at an issue that refuses to go away, bad loan resolution under the new institutional mechanism set up under the Insolvency and Bankruptcy Act, IBC. It's now almost 9 months since the Act and the rules thereunder were notified. So let's take a look at the scorecard. How far has it succeeded in achieving the lofty objectives with which it was passed? Speedy and satisfactory resolution of bad loans. Even as insolvency professionals seem to be struggling to come up with answers, the impasse in the JP Infratech case does not bode very well for the IBC. And who better than to discuss all this, what's happening in this space, than two experts who combine the best of both theory and practice. I have with me Pradeep Kumar, former Managing Director, State Bank of India, and Piyush Joshi, partner Claris Law Associates, who's been advising large corporates for years now. Welcome to the show, Pradeep.
Thank you, Mythili.
Let me start by asking both of you in turn whether you had actually anticipated the numerous problems the IPC is running into, whether it is a shortage of insolvency resolution professionals or of enough benches and qualified members, both judicial and technical, lack of infrastructure, etc., that we are now seeing in implementing the IBC. Let me start with you, Pradeep. Also, do you think that part of the problem really is because the IBC and the FSLRC, the Financial Sector Legislative Reforms Committee, which in a sense fathered the IBC, was overwhelmingly dominated by academics and lawyers who perhaps have little experience of the actual nitty-gritty of bank lending? Pradeep?
I would like to comment on the composition of the committee which decided it, but this is the law, and as bankers I think this law is much better than the earlier laws that are available for resolution and recovery, maybe the DRT and the SAFEC. The greatest advantage of this law, according to me, is the handing over of the possession to the representative of the COC, that is the insolvency resolution professional, and the IRP will be running the company during the process when the rehabilitation package or the resolution package or the recovery action is in force. I think this is the greatest strength of the IBC code, which gives bankers confidence that this will not be the case where the promoter will continue to sit in management and strip the company of the assets. Of course, this is not a panacea for all the ills that we are facing, but I think it's a step in the right direction. Initially, I think we'll have a lot of teething problems which we'll have to resolve, the IRP is a single individual. How does he collect a team amongst himself? How does he manage to throw out the promoter? What are the pinpricks the promoters will give him? And then when it comes to the COC is a committee of creditors, basically in many cases large public sector banks, large number of public sector banks. Will they be able to take a speedy decision because they have got a timeline of 180 or 270 days? These are all issues for which we don't have answers right now, but I strongly believe we are going in the right direction.
Okay, so we're going in the right direction even though it may not be a complete panacea. That's good to hear, Pradeep. But Piyush, your take first on whether you had anticipated these kind of problems, and then I'm going to ask you for a dispassionate assessment of your tribe. Would you agree that the best laws are actually those that are drafted by those who combine an understanding of the law with ideally experience and practice in that field? So in fact, if you have a law, say on negotiable instruments, it would be good if you had a legal expert who also worked in a bank rather than somebody who only had a theoretical knowledge of the law.
Yeah, so Mythili, so in terms of the teething problem, yes, it was very well foreseen. In fact, even on your programs, we had discussed that there are issues that will emerge. And the real issue was that the way that law has been drafted, it has been picked up from the United Kingdom law. And it was not even picked up as the updated law. So the whole chain of experience that the UK has gone through with this particular sort of regime was not absorbed fully in its implementable form when it was brought here. So we have to unfortunately go through that circle, which the Supreme Court in JP has also, which actually the Advocate General before the Supreme Court and JP Infrastructure clearly said that these situations were not foreseen at that time. But it is foreseen that there are a severe number of circumstances, infrastructure being one of them which has been totally ignored. JP being a housing company brought out the issue of the
in a very human way perhaps.
And that hits home completely with the common man as to, yes, if I am I in that position that if I give money to someone for a flat, will I be still sitting and waiting, and will the secured creditors take away everything and I will not get anything? But these issues were foreseeable in the sense that the shortcomings of the Act were visible when it was drafted. Now the issue on the drafting, it is also, I would agree that there has to be a balance between lawyers and practitioners of finance in a particular financial law. But you do need our tribe specifically for ensuring.
We can't unfortunately do away with you. That is the truth.
Unlike whatever Shakespeare may have said, but you still need us here.
Absolutely,
and
unfortunately,
yes. The issue is that the rush with which it had come out had resulted in a lot of things not being put on board at that time.
I guess there always
and it being
are.
saying it will evolve in the Indian circumstances. And that is what we are facing. We will evolve.
I guess so. But there will be a painful period, I suppose.
There will be a painful period. It cannot be expected that, yes. And also in India, there's always this thing of one law has to resolve everything. And I keep stressing, and I cannot stress enough, that this is an insolvency resolution law. It cannot have equity. It cannot be equitable. Yes, if you're looking for exact humane equity issues, don't come within the insolvency regulation.
What, in fact, I'm going to ask Pradeep, particularly because you spoke about equity in the context of the JP Infratech. Pradeep, how do you view the Supreme Court ruling in the JP Infratech case, where the court has vacated the earlier stay on proceedings? Of course, that's very good, but with the proviso that the insolvency resolution professional must keep the interests of 32,000 buyers of the company's flats in mind. Agreed, if you and I were there, we would entirely empathize with this. But even so, then what about, would it be correct to say that their rights cannot rank superior to those of the secured creditors? Because there are two reasons why I say this. Because if that were to happen, then banks would be very wary of lending in future, because what is the idea of a security? So will there not be these problems? How do you interpret the JP ruling?
So I empathize with the individual flat buyer. So like if I was a buyer, maybe I would also be affected. But yes, I agree with you. The Supreme Court has to take into consideration very clearly the waterfall mechanism in the law has been given. The waterfall mechanism clearly indicates the first in line of the secured creditors. I think the apartment buyers are technically unsecured creditors. It is a difficult decision for the IRP to resolve, and the court has said the IRP has to deposit 2,000 crores. From where will he get 2,000 crores?
Maybe from the parent company.
He has to get 2,000 crores by selling securities. Their securities are charged to the secured lenders. Will the secured lenders allow the IRP to sell the assets? I mean, I don't think we have answers to this question. I believe Supreme Court has not applied its mind. It looks strange that the Supreme Court has to overturn its decision within a week. That means they have not applied their mind.
Apart from which, Pradeep, do you think
and again here, yes, I do empathize with the small apartment buyers because they are very small compared to the bankers. But if their claims are treated as ahead of the secured bankers, then I can assure you no real estate project where there is individual buyers are there is going to be financed by a bank anymore.
Apart from which, Pradeep, I think has the Supreme Court lost sight of the fact that banks are not actually lending their own money. That money belongs to the thousands of depositors, many small depositors, in fact, who could be poorer than the house buyers. So I think has the Supreme Court lost that, and they're seeing it as a battle between a big bank and small home buyers. So has the Supreme Court, as I said, not understood the situation? What do banks lend? Banks lend the common man's money, not their own money. Would you agree?
I think this is lost sight of in many times when there is a tussle between a bank and a relatively small entity or a individual. People forget, and many times the governments, the courts forget that bank is only an intermediary. It intermediates between the small depositors and the borrower, whether it is small borrower or a large borrower. Ultimately, if the bank loses money, it is passed on to the small depositor in terms of reduced interest and maybe additional higher cost, operational cost for all the services it renders. I think many a time this is lost sight of us. I agree with you fully on this.
Absolutely. This is why I said practice and theory both are equally important. But Piyush, does the Supreme Court ruling in this particular case throw a spanner in the works in the sense that could it be a forerunner of similar judgments? We're already seeing Amrapali buyers are thinking of going to court. And in that case, you know, there would be attempts to ensure that banks are able to recover their loans speedily, because this is what the entire purpose of the IBC was. The remedy for the aggrieved flat buyers really has to be civil or criminal court procedures wherever there's a fraud. And what we really need to do is improve the functioning of our legal system. IBC is not the way to ensure justice is done to the flat buyers.
On the specific JP Infratech issue, I think first of all, Supreme Court has, these are all interim orders as yet. Interim orders are passed within 10 minutes of hearing, even lesser. You will have, if you see the courts these days, you get your order within 5 minutes of hearing. Right. But the issue is that ultimately when the law is crystallized, the Supreme Court will realize, and it will have to take into account the fact that they are dealing with insolvency resolution. They are not dealing with equitable relief for the home buyer. They are separate laws which have been passed and enacted. There are separate branches of law which deal with what exactly has happened with certain circumstances. The situation of the JP home buyers, reliefs are there under separate action, separate branch of law. Insolvency is not where the relief will be provided to an individual home buyer.
But surely the Supreme Court understands that. So why did it give a ruling like this, even if it is not the final ruling?
No, so the issue is when a judge is faced or a bench is faced with equity, the notion of equity runs very strong in the Supreme Court because it's the last stop. So the judges,
I thought the job of the judge is to just interpret the law, not to put his own value judgment.
We'll have to then go into how Indian judiciary has evolved, because we started as a common law system where this is very clear that, so if you see the 50s judgments, it's very clear this is the clinical law that there is. But once you start seeing the way the laws started impacting the common man, and its access to justice got denied through executive action and then through political action, the judiciary becomes the last stop. So what has happened is, if you go to the Supreme Court today, it's a heavy burden on the judges individually, that with each case they try and resolve that, since they are the last stop and someone has come there, what is the equity or the justice that can be delivered?
But doesn't the judge see the equity between the small depositor and the small flat buyer?
So that comes out in actual legal arguments, not in an interim stage. In the interim stage, it will be, let's balance this. And the balance that comes out of 10 minutes or 15 minutes of arguments is, JP is a large group, it can deposit 2,000 crores, everyone will be at least seeing the money. Let the IRP, who's the actual guy, come up with a plan. That is exactly how this would have fallen down. When the actual arguments are heard and the law is actually crystallized out of this case, we will find the actual law being distilled, which will be more towards how that IRP resolution, insolvency resolution is insolvency resolution. Relief against inequitable behavior by promoters, fraudulent action by promoters is a different category. And we have got a real estate administration tribunal coming up.
We have RERA also.
RERA coming up. The point is, the Supreme Court should very well direct with these cases the RERA be strengthened.
Absolutely.
And a lot of states are just delaying that on the cloud of the cloud of the developers. That is where the Supreme Court can push to say that get that system going in place so that these circumstances don't arise, and home buyers have an immediate remedy, rather than having in the insolvency situation the status of secured lending itself being questioned, which has a far larger impact.
Actually, a huge macro impact also. Apart from banks, there's the entire economy also that is concerned. But I'm afraid on that note, it's time for us to slip into a very short break. But please do stay with us. We'll be back very soon. Welcome back. You're watching Macros with Mythili, and I'm discussing with Pradeep and Piyush about the complications that the IBC, the Insolvency and Bankruptcy Code, is running into in real life, and what do we do to get out of this scenario. Pradeep, in one of the first cases that actually went into resolution, the Synergy Dore Automotive Limited, the Hyderabad branch of the NCLT approved a scheme put forth by the IRP, wherein banks had to take a 94% haircut with the payments, for a minuscule 6% being made over a period of 3 years. And finally, ironically enough, the company was merged with Synergy Castings, which is a related party, which actually got the borrowing company at a dirt cheap price. Is this the kind of resolution we want, where banks take the hit and the borrower company seems to get away cheap? Of course, Edelweiss ARC is set to appeal to the appellate tribunal against this order. But has it set a dangerous precedent, Pradeep?
I think it is a very bad precedent because I think a related party is involved. I do not know who made this resolution plan and how this got approved. I don't know the details of the case. Of course, I have read about it in the newspapers and the internet, but it seems to be a very strange sort of resolution plan where it is sold to a related party, because RBI frowns even when we do a normal restructuring, selling it to a related party. So I think it is a bad precedent, and the amount of recovery at 6% seems very nominal. I do not know what is the underlying security that is available, so it will be very difficult for me to tell, but I think it sends the wrong message to the banking community, and that even this act is not strong enough to enable the secured creditors to recover their money.
Piyush, would you agree that this is not what we envisaged when we framed the IBC, and the situation now doesn't seem very much better than before? Also, I would like you to comment on the fact that is there not some ambiguity over the role of promoters and shareholders? Do they have a say or not in the COC? Does the IBC override all other laws? There seem to be different interpretations on that. What is your take, Piyush?
So, these things, as I said, it's evolving. We have to. But this particular case will have to be dealt with strongly at the appellate level. It has to be put if this case is not at the appellate level taken harsh, with a view to resolve this, then you are right, we will face that this also will result in situations which it was supposed to be curing. But as of today, all these issues exist. The promoter shareholders role is unclear. It is also a result of the fact that if you have an individual IRP, because what you saw in UK, for example, it's always a big four firm. 98% of insolvency resolutions in UK are done by one of the big four firms.
So why did we insist that the IRP should be an individual?
Now, that is again outside my focus. But if you are looking at importing a set of laws from a jurisdiction, you have to have seen how it is actually being implemented. Now, it is being implemented by institutions and not individuals. So what happens is, because you have an individual IRP, he has to be dependent on the existing people who are managing a large company for 20, 30 years. But you cannot have an expectation that it will only be, the IRP will be the statutory, like a judge who has come in and he'll have this statutory shield and it will all be fine. But he needs support, and you therefore need a backing of at least some number of team who will evaluate it. And an IRP and who is an individual will see a schedule or a CFE which gets approved by a committee of creditors. He'll rely on that. It's not that he's exercising some individual judgment once the creditor committee has approved it.
What is the great wisdom that he brings? It's very difficult to run these complex companies.
So
because
it is more like a person who comes in to have everything away from the promoters till the creditors committee comes out with a resolution. Now, the committee of creditors itself will obviously rely and interact with the promoters to say how best can this be resolved, because only the promoter knows where the assets are. He will know where.
That's the reality of Indian
business.
That's
the reality, because unless you do a full audit and a forensic audit, you'll never know where a large group has gone. In fact, it's only in India that we have the
concept of promoters, even in large companies.
Exactly.
We don't have the concept
of... the issue with this part, the first resolution of its type is clear that this is not what this act is supposed to do. And you have to have an appeal going up and the NCLT looking at it and shoving it back saying this is not.
So we'll have to see what happens. But Pradeep, would you agree that the IBC's failure to distinguish between financial and operational creditors results in running the risk of two things? One, operational creditors tend to use the IBC to settle relatively small disputes that would normally have gone through the civil courts. In one case, an operational creditor apparently took a company to the NCLT for non-payment of little over 10,000 rupees. And B, financial creditors might become very wary of lending, because if companies are going to be taken to the cleaners for very small disputes, it could rock the boat and affect the functioning of many companies, making them potential NPAs. In fact, you now have a situation where the IRPs are approaching banks for loans as part of the resolution process. And that begs the question, why do you need the IRP at all if they're finally going to the banks? Banks themselves could have come up with a program. What do you say, Pradeep?
Yeah, the first question is about operational creditors. I think the amount that the law says is any amount above 1 lakh. I think 1 lakh is too small an amount. I mean, in the context of the current NPA Menace with huge running into thousands of crores, for somebody to go to the approach the NCLT. And of course, a small creditor always creates, operational creditor creates problem for the larger financial creditors. I think this ceiling amount of 1 lakh has to have a real look. As regarding the IRP, individual running IRP running it, I think that is a big question. As Manoj was saying, in the UK it is mainly the big four. I agree that it will be very difficult for an individual to run a large enterprise, particularly if you see the 12 cases that have been referred to the IBC by the banks. There are 3 large steel companies, 3 or 4 large steel companies. How can one man run the steel company? He has to have the entire management team with him. Will the management team cooperate with him? That's a big issue, because I don't know whose side the loyalty is. The management team's loyalty may be with the promoter. The other issue which you brought up is the requirement of funds during the 180 or 270 days. I think most of these companies are stressed, their working capital is in deficit, and if the company has to be kept afloat for the next 180 or 270 days, I think they require funding. Of course, the problem in this country is we have never had this funding. Whoever funds this gets priority charge, and consequently the current secured creditors are very uncomfortable. But this is the practice world over. I have been in the US where we have many such bankruptcies being dealt with. There's a concept of debtor in possession. The debtor in possession approaches various financial institutions, including the current institutions financing which have lent to this company, to give a debtor in possession financing to keep the company afloat. I am told what I've heard in the system is the banks are very uncomfortable with providing additional finance to keep the company afloat. But I think the banks have to see the larger picture. If they have to recover and sort of resuscitate these companies, I think it is in their interest to keep the companies going for the next 180 to 270 days, and to an extent some finance will have to be provided to ensure that the IRP keeps the company running. Yes, it's a difficult call for the bankers, but it's a call they have to take looking at the larger picture.
Okay, that is true. It is a difficult call. But Piyush, under the IBC, there is a distinct shift from secured to unsecured creditors. In fact, an August 2017 research paper by IGDR says that the new insolvency process has been used more by operational and unsecured creditors than financial creditors. Now, is it not important to distinguish between the two? Because when a secured financial creditor gets hurt, he is going to stop lending, and that impacts the larger economy much more than if an individual operational creditor were to not get his money back.
Right. No, so the importance of the operational creditor is more for continuing as an ongoing business. Okay. So the idea of recognizing the operational creditor, bringing him on board, is essentially like a gas supplier or electricity supplier to keep the mills running. It was not meant to have your local canteen to also be operational or your consultants to be operational creditor. It was to ensure and recognize that people who are ensuring the business to continue as a going concern are recognized in the system, and which is what the limitation should have been, that is the operational creditor critical to the ongoing business
I think they really
and continuing it. And that's been glossed over. So you have consultants having a grouse for not having been paid for 2 months, filing Section 8 notices. But that will have to be undertaken through a statutory amendment soon. Otherwise, this will become like the NCLT will get swarmed by irrelevant operational creditors.
In fact, there's a very real danger of that.
It is already happening because we have defended ourselves, and we are not a large litigation practice at all. But the projects that we are advising are facing Section 8 notices from suppliers of security guards or canteen, taxis.
So this is really all part of the learning process. But since I'm running out of time, very quickly, Pradeep, does the IBC actually miss the wood for the trees by ignoring the need to really preserve value in a country like India? Because unlike the US, where we might find to liquidate a power plant or a steel mill, in a country like India, these are very scarce resources which have been built at considerable cost. And the attempt must be to preserve value rather than rush them to the cleaners. Would you agree, Pradeep?
I agree. I think the intention of the IBC is not for ultimate recovery, but for ensuring that the asset is used and functional, and there is an ecosystem which is built around these large companies, and that ecosystem must survive. But at the same time, there has to be a method, an orderly method of liquidation also, which is, I think this is what is provided for. The good point is whether 180 to 270 days is sufficient for all these things. That is debatable. Other thing is, the Act itself should ensure it should be a deterrent for the corporate debtor to be taken to the NCLT. He should ensure that he will never be dragged to the NCLT, and that should be a deterrent. This is the last resort, and I think if that happens, and if you are able to have a demonstration effect of one or two large companies, whichever sector it is, where the promoter is thrown out and new investors are brought in, the company is saved, and the banks, of course, may have to take a haircut, but the existing promoter takes a huge haircut. If that is demonstrated, that I think will keep the promoters will be wary, and they will ensure that the company will never be referred to NCLT.
That is true. In fact, it is demonstration effect that is most important.
This should be more of a deterrent rather than a method for recovery of the bank.
Absolutely. Prevention is always better than cure, but I'm afraid we've run out of time completely. Yeah. So we'll have to end this discussion. The proof of the pudding, it is said, is always in the eating. Likewise, it's only when it comes to actually implementing the IBC that we are seeing where the pitfalls are, and possibly try and rectify them, as you suggested, Piyush, through amendments to the Act. Thank you so much, Piyush and Pradeep, for joining me in the discussion and sharing your views on how we can tweak the code and make it more meaningful. Thank you also for watching. Remember, we'll be back next week with yet another edition of Macros with Mythili. Till then, it's thank you and goodbye from all of us at TT Now. In the meanwhile, if there are any issues that you would like to see discussed in this program, please do write in to us at the email ID you see at the bottom of your screen.